Hey everybody, welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel, doing our weekly live stream where we talk about all things debt related, whether it's horrible things like bankruptcy, debt collection, lawsuits, wage garnishment, whatever it is. Those are the kinds of things we talk about. I do this live stream each and every week to provide people with information and resources on how to deal with some of these things that keep you up at night and cause a lot of stress. I'm an attorney in the state of Arizona. I'm only licensed here, and this video doesn't create any type of attorney-client relationship or should not be construed as legal advice. These are my weekly disclaimers that this is me just talking on YouTube, so take it for what it's worth. And so what I like to do each and every week is if you have questions, particularly, go ahead and put them in the chat section, whether you're watching on YouTube or whether you're watching on Facebook. Go ahead and put them there. I'll put them on the screen and we can go over it and discuss kind of where some resources that I think that, I can point you in the right direction of, whether you need to talk to an attorney. And particularly if you're not in Arizona, like if you're in Arizona, I can speak with you. My information's below and you can set up a consultation. But sometimes if you need an attorney and you're out of state, I can direct you in a different direction for that. I also want to direct you to the chat section where I put a link to one of the great sponsors of our weekly live stream, SoloSuit. I know a lot of you have used SoloSuit. It is an awesome company that helps people in drafting answers to lawsuits, motions to compel private arbitration. They have some cool debt settlement tools. So go over there, check them out. Click on the link there. That's a great way to give yourself some additional resources and a great way to support the YouTube channel that we do each and every week. All right, let's jump into it. Hercules was here nice and early. Said, I lost to DNF Associates yesterday. Sorry to hear that. I asked the judge to order them to present the purchase agreement. Judge said no. Will the judgment appear on my credit report? So I should tell you this. Let me just kind of back this up and kind of deconstruct this a little bit. Now, if you're in it, sounds like you're in trial. If you're in trial and you're asking the judge to have them produce things, it's too late at that point. At that point, basically all documents have to be exchanged, all requests have to be done prior to you actually getting to a trial type setting. So I don't know all the details of that, but that's kind of one thing that stood out to me from your question. Now, as far as judgments on your credit report, this is one of the most misunderstood and kind of myths out there, is that if you get a judgment against you, it's going to show up on your credit report and cause all kinds of problems. It can cause some problems, but it's not going to show up on your credit report. Back in, I think it was 2017, they changed the rules on how judgments show up. They don't show up at all in your credit report. They used to show up in the public records section of your credit report. That's where things like bankruptcies, tax liens, those kind of things show up. If you had a judgment, that's where they used to show up, is in the public records section. The problem is it was too hard to say who is who. There are all kinds of problems at the big three, TransUnion, Equifax, Experian. They were running into problems that there were judgments that were being put on people's credit, and they weren't able to make sure that it was the right person. So it was damaging people's credit who had nothing to do with the judgment. So basically what they said is, look, we're not going to report any judgment in the public record section of your credit report unless it has your full social security number on the front of it, which was a convenient way for them of saying, look, we're not going to do it anymore, because if the court were to put your full social security number on the front of a judgment, there would be all kinds of issues for the court, for the creditor, everybody else. So you're not going to see it on your credit report. They could record it with a county recorder. It could act as a lien against real estate. They could use it to garnish wages, garnish bank accounts. Those are the types of things they're going to do with it, but the credit reporting is not going to be a bigger issue there. All right, let's see here. This one says, what do I have to do if my car is in a crash, not full coverage? So there's not full coverage. I'm taking it like insurance. What can I do to the bank if they repossess the car? Okay, so if they take your car, this is a good question. So if your car gets repossessed, typically the normal cycle of things is if you don't make your payments for anywhere from, it's usually around 3 to 4 months, could be 2 to 3 months, your car's at risk of getting repossessed. And so the lender on your car, they have a lien on your vehicle. That means they can come and they pick it up through what's called self-help, where the lender comes by, the tow truck comes by, picks up the vehicle, and then they take it and they sell it And they take those proceeds that they get from the sale and they apply them to the loan. And any balance that's still owed is called the deficiency. Now, the deficiency balance in most states, what I see is that they will often sue on the deficiency. They often don't get a whole lot for the vehicles. They take these vehicles to an auction. They auction them off wholesale. Or in a case like this, if the car is crashed and there's no coverage on it and it's totaled and you're not going to be able to pay for it anymore, they're just going to go and, take it to the dump, whatever, junkyard, that kind of thing. So if you have that deficiency balance, there's a couple things you can do with it. Most states require them, they provide you some type of notice that they sold it, what they got for it. When it comes to repossession, these statutes are very state specific. In Arizona, they're like crazy complicated too. There's all these different steps they have to take. And what you can do is you can either try to negotiate it, negotiate some type of settlement with them, or two, you can look at like a bankruptcy option. Because if you don't settle it, they are likely going to sue, particularly if it's a large amount, they're likely to sue, and then you're going to end up in a situation where they're going to be able to come after you for that balance. So, and that a lot of times will push people into like a Chapter 7 type bankruptcy. That'll eliminate it completely. So, all right, let's see here. Devin says, I want to claim bankruptcy in the state of Maine. I have 2 vehicles. One I owe 11 grand back. What should I do? So this is where it's interesting when it comes to bankruptcy. Bankruptcy is a federal law. It's the Bankruptcy Code, Title 11 of the U.S. Code. That's where all the statutes are found. However, there are some state-specific exemptions. Each state has their own set of exemptions that can protect a certain amount of your assets. And so what we do, I can do a quick Google search. If I were you, I would go to Maine Exemptions, Vehicle, Bankruptcy. I'm going to do a quick Google search, and that's going to give me at least a general idea. Now, these are, who knows if these are right or wrong, but it says right now that Maine bankruptcy law allows individuals to protect up to $5,000 of equity in your vehicle. Now, if you're filing bankruptcy and you still owe money on it, you can still keep the car as long as you keep making the payments on it, and as long as you don't have more than $5,000 of equity. Double check that. I'm not saying it's right. I'm not saying it's wrong. I'm just doing it as an example. I did a quick Google search. That's what I saw. So, for example, you say you owe 11 grand on one vehicle. As long as that vehicle then did not have a value of more than 16,000 total, because that would be 16,000 minus the 11,000 you owe on it, leaves $5,000 of equity, which would mean that the vehicle is protected. You could still go through bankruptcy, keep the vehicle as long as you can't make those payments. However, you also have the option in Chapter 7, you could surrender the vehicle through the bankruptcy, and then you wouldn't owe anything on it going forward. So that's an option as well. All right, let's see here. See, Alex is back. Alex, it's been a while. My friend down in Yuma. It's good to see you back on the channel. If your collection case goes to trial, do you have the right to remain silent and not be required to testify? Supporting from Yuma, Arizona. So good question. So if you go to trial, so civil cases, a lot of times you see on TV, people will plead the Fifth, maybe see in like a congressional hearing or something. They plead the Fifth Amendment saying against self-incrimination. It's important to understand that only applies in the criminal context. It does not apply in civil cases. And so if you show up to a trial, a debt collection trial, they can call you to the stand. Even if you're represented by an attorney, they can call you to the stand and have you testify, and they can require you to do so. And not only that, in criminal cases, if a defendant doesn't testify, often there's an instruction to the jury that says that you can't hold that against them. Not true in civil cases. They can hold it against you and assume that there's a reason that you don't want to do it, and that's the reason they're going to assume is because you owe the debt on it. So good question there. Jaden says, my old apartment management is going to sue me for move-out charges. They just took over management. I got a replacement tenant, cleaned the entire place, gave them notice. What can I do? Often in those situations, if they haven't filed the lawsuit, you may be able to enter into some type of negotiation with them, depending on how much they're owing. If it's something where they're asking a lot of money that you feel like you just don't know, sometimes if they're not willing to work with you, the lawsuit is counterintuitive as it sounds, can be the best thing. Because it kind of brings it to a head. It brings it into a court setting. You might be able to go through mediation and be able to have a mediator come in and help broker some kind of settlement. Or if you're legally right, if the landlord's trying to do something that they're not permitted to do, it could be something where you might be able to press the issue and actually prevail on it. So that's what I would tell them to do. All right. PJJ says, why does a creditor tell you they write it off, like due to COVID, and instead of sending you a debt cancellation 1099, they sell it to a shady company who harassed you? So and this is a good question because it's often misunderstood. I often say this is the thing I get the most grief online about is the charge off. The normal collection cycle of a debt, like a credit card, is they will do internal collections for anywhere from 3 to 6 months. Sometimes they'll hire outside collection agencies who will just call you and be annoying. They try to collect on it for 6 months. But once it's gone 6 months of no payments, the law requires them to charge it off. Now, the charge off does not mean that they can't collect on it. It doesn't mean that they're collecting any insurance. It does give them some tax benefit. They're counting as a loss on their books. Some people think, there's insurance that's covering that. There's no insurance for private companies. It's a loss on their books. So what they'll often do is they will sell it to junk debt buyers who will pay them pennies on the dollar for it. And that's their way of recovering some of the loss there. So that's how it is. Unfortunately, that's the way that they're that they do it. But yeah, unfortunately, they can do it. So Tino says, Consumer Warrior, you're a blessing. I got me a great lawyer in Washington. I'm ready to go next month. Bless you. Thank you, Tino, for being on the channel today. I appreciate your kind words there. So, all right. Dennis says, can you give a quick overview of how a senior on Social Security can avoid collections? Well, I can tell you this. So if you're on Social Security, I don't know if you can avoid collections. I mean, the collectors they can still call you. They can still be annoying. They can still sue you. They can still get a judgment. The one thing they can't do is take your Social Security. Social Security is exempt under federal and pretty much all state laws. And so they're not going to be able to take that, whether it's in a bank account or, they can't garnish the federal government to try to take that money from you. So what you have to be careful, though, is if they have if there's a credit card, medical bill, something like that, if they sue you and get a judgment, they still may be able to do things like lien your home. If you have other income from, employment or something like that, they may be able to garnish that. So you got to be careful when it comes to that. So, all right, let's see here. Do I think if I owed $18,000, could I negotiate with the debt collector for $5,000? Depends. The infamous, famous attorney response. It depends. So when you're negotiating, the way to look at negotiations with creditors is when you go into the negotiation, you've got to assume they have some information on you, particularly if they're a big junk debt buyer or if they're a creditor. They might have information about your work, your salary. They can do a public search on assets. Do you own your home? Do you have vehicles? That kind of thing. When you're going into trying to negotiate this, and I know that your question from before was this was a vehicle that was totaled, and now you have this deficiency balance. There's this balance that's still owed, even though you don't have the car anymore. You could negotiate, but your job in the negotiation process is to explain and really sell to whoever is trying to collect why it is they should take considerably less than what is it they're owed. So that's a pretty big discount. Okay. So if we're looking at, I got my handy dandy calculator here. So you're asking them to settle for 27%. So about 30 cents on the dollar, 30% settlement, pretty big discount on a deficiency balance. However, if you can come to them and say, look, creditor, here's the situation. Here's my job situation. I don't own a home. I don't have any other real estate. I've also got a lot of other hardship going on. I've got a bunch of other debts or some lawsuits. Maybe if you have child support, if you're paying spousal support, alimony type things, if you already have a wage garnishment, if you owe a bunch of taxes, those are the kinds of things you can go to them and say, look, I've got all this other chaos going on. It's making it difficult. Here's the best I can do. And what you're trying to do is paint a picture to them of, look, creditor, this is as good as it gets. If you don't take this, it's probably going to get a lot worse. I don't usually recommend going in with the bankruptcy threat. The reason is bankruptcy is kind of a cry wolf thing. All creditors say it, or anybody who owes money, they say that to the creditors. They know that a certain percentage of people will file bankruptcy, and it's really kind of baked into their analysis on how they're doing the debt collection. They know a certain percentage will, and often you'll get them say, well, okay, just let us know when you file then. They know a lot of people aren't, and they even know, particularly the big junk debt buyers, they'll have information where they have an algorithm that helps them to guess who will and who won't actually file bankruptcy on them. So that may be something to take a look at. As far as, those are the kinds of things you need to present to be able to help them out. So something that was brought up earlier today is let me see. It was a good comment from the channel. It said, someone showed up to my house and handed my fiance paperwork. They didn't hand me anything. What should I do? Should I follow the instructions on what was handed her, or do I ignore it? And so this was a debt collection lawsuit. So service of process. I just had a hearing today, an oral argument. We got a good victory today. It was actually a pretty big victory today. Arguing about service of process. Service of process is when you get sued by a debt collector, they're required to provide you notice. So in a situation like this, the question is, if you got sued and they show up to your house, you're gone, they leave it with your fiance, does that count if they don't come by and put it in your hand? In most jurisdictions, the answer is going to be yes. They have to come by, leave it with you or someone of suitable age and discretion is what most of the rules say. This is usually Rule 4 in the rules of civil procedure in most states, Rule 4. So you can go look at that. Most courts don't define exactly what suitable age and discretion is. Could my 14-year-old kid accept service? Probably. That's terrifying that my teenagers could take it. But yeah, they probably can. And so in this situation, yeah, your fiance being there, assuming that your fiance is living with you. If your fiance is just visiting there, doesn't reside in the property, then no. But they can serve someone who resides with you. So particularly if you get a default judgment against you, it's important. The first thing I do when someone calls my office here in Arizona, I start going through the file, looking to see, okay, how did they serve you? How did this default judgment come into place? And start picking that apart. Because like for instance, the case I had today, there's a judgment of about $60,000 default judgment. They absolutely did not give notice to the defendants, but they got a default judgment based upon kind of some unique facts. We were able to go in and argue, look, Judge, they didn't follow the rules. They didn't give them proper notice. And at least in Arizona, it gives you a basis, even if it was a long time ago, to be able to try to unwind that process. So making sure that you get served appropriately, and if there's a default judgment, having an attorney, if you're in Arizona, I'm happy to look at it. I can tell most clients in 5 minutes if they've got a case to get the judgment set aside or whether we're going to have to deal with it. So, all right. PJJ again says, how much does an average lawyer cost or charge for bankruptcy? Ballpark figure. It does. It's a good question, and it varies on chapter, and it varies from state to state. And I have always been surprised how much it varies from state to state. I know that in Arizona, where I practice, a Chapter 7 could range. Right now, they're probably ranging around on the low end, maybe like $2,200 plus the court's filing fee. On the high end, especially if you own a business, it could be anywhere from $4,000 to $5,000. It's typically done on a flat fee. I know with my office, we do zero down bankruptcies, which means we don't charge anything up front, and then we break the attorney's fees up into payments over time. That's something that's just recently has been 5-6 years that we've been allowed to do. It makes it a lot easier. They used to require people to pay it all up front, which never made any sense to me at all. But like I know here, I'm in Arizona. Like I said, Utah, I've talked to attorneys just in the state to the north of us, up in Utah. It's quite a bit cheaper. It's like $1,500, $1,500 to $2,000, depending on. So a lot of it depends on local practice, some of the requirements of the court, the bankruptcy trustees. Some attorneys don't do the payment plans. They don't, like I said, we do the zero down payment plans. There's some attorneys that don't. Some states do not do that. I always say to ask if they do it. But I think that you're probably looking around $2,500 to $3,500, maybe a little more if you have a business for a Chapter 7 bankruptcy. And now that I'm saying this, there's some attorneys, and I'm recording this for future reference. I'm recording this in August of 2024. And so they do kind of go up with time. I can tell you, I was actually just looking. I filed my first bankruptcy case for a client back in June of 2005. So long time ago, 19 years ago, I filed my first case. The typical filing back then was about a 40-page document. It's now over a 100-page document. And the reason why is they keep adding more and more information that has to be disclosed, more transactions. Trustees in Arizona are getting pretty aggressive. Just can be there's a lot of issues that can come up. It's a lot more work than it used to be. So, all right, let's see here. This one said, what can I do to credit acceptance if they're still reporting that I'm delinquent when the Gap company sent me a letter saying that everything was paid in full? And in the letter, it breaks down the exact amount that everybody paid the insurance company, the Gap company, and the refund they received, which left a zero balance. So usually something like that, particularly credit acceptance. I always say the first thing you need to do, courts always want to see kind of just at least an initial attempt to resolve the issue prior to jumping into a lawsuit. But before you do anything, I would probably contact an FDCPA lawyer in your particular state. That stands for the Fair Debt Collection Practices Act. Depending on the type of debt, depending on credit acceptance and what they're doing on a day-to-day basis, you may have a claim against them and be able to pursue them not only for statutory damages, but attorney's fees, court costs, all that kind of stuff. So, all right, I think that'll do it for a Thursday evening. I appreciate everybody tuning in. Go ahead and click on that link. Go check out what SoloSuit has to offer. They have some really cool tools and technology that can help you to deal with debt problems and pretty difficult debt situations. If you're in Arizona, my information's below. You can get right on my calendar and you'll talk to me directly. I'm happy to see how I can help you out. But hey, y'all have a good night. Thanks for checking in. We'll talk to you next week.